Our last case of the morning is Janini versus London Township Condominium Association. This is also a 15-minute mini oral argument on the application. Good morning. You both have 2 minutes of a free fire zone, which you may waive. And we ask that if you would like to reserve time for rebuttal, that you keep track of your own time. Thank you.
Good morning. May it please the court, Kelly Cruzy appearing on behalf of the plaintiff appellant along with trial counsel Howard Radner. I'd like to reserve 3 minutes for rebuttal. This matter is before the court on a single question. Did the Court of Appeals and Franchetti versus Fox Chase Condominium Association correctly conclude that a condominium owner is neither a licensee nor an invitee when injured in the common area of a condominium development? And I respectfully suggest to you that the answer to that question is no, it did not. Condominium unit owners, such as Mr. Janini, should be considered invitees for purposes of premises liability lawsuits against their condominium development associations. Condominium owners, such as Mr. Janini, are invitees first and foremost because the law in this state is clear and undisputed. Liability for a dangerous condition on the land is premised upon possession and control. Which party has possession and control? And that is because the man in possession is in the position of control and normally best able to prevent harm to others. Here, there can be little doubt that it's actually the association that is the party in possession and control of the common areas. And it defies credulity to suggest that Mr. Janini, who is just one member of the association among several hundred, has any control over the maintenance of the common area. The argument that a condo owner can't pursue a claim because it's tantamount to suing himself is really a red herring, because he's not suing himself. He's suing a distinct legal entity, the association. And it ignores the reality of the situation that exists in these types of situations. Individual members like Mr. Janini have absolutely no individual rights when it comes to maintaining or controlling the common areas. They are specifically precluded from altering the common areas. All of their rights have been ceded, their possessory rights and their rights to control have been ceded to the association. He is much more analogous to a tenant, and the situation is much more analogous to a tenant-landlord situation than any other. Michigan courts have repeatedly recognized that an owner can cede their rights to possession and control in both the Finazzo versus Fire Equipment Company case and the Merritt versus Nicholson case. And that's what exactly happened here and in most other large development. And if you look at Google Maps, you'll see this is a large development, as I did, where the individual owner is just one person. It's not like I have control of my own driveway. He has no control over how this area is maintained. He can't go out and hire his own snow removal company. He can't decide he wants to paint the sidewalks purple. He has no control. The association does.
Counsel, sorry. I was just gonna, a little bit off of this, but can you, I understand your argument to be that the duty that defendants owed your client sort of arises from the master deed, right? Their requirement to maintain the common areas. Why, with that focus, why is the claim for your client not one that sounds in contract as opposed to tort? And are there some reasons that a contractual claim, is not the right fit for this?
Well, I would say two answers to that. First of all, it also arises out of the common law that recognizes that the party who's in possession and control is the one best able to prevent the harm, and that is a tort claim. And so, like the cases we've cited from around the country, that's been recognized that in these situations, the analogy is to a landlord-tenant and an invitee-invitor relationship. And if I could, I'd just like to point out that several of the cases that the defendant relies on have either been overruled, abrogated by statute, or show considerably different factual situations. But With respect to the contract claim, the procedural history in this case, the motion for summary disposition was denied at the trial court level, so the opportunity to ask for amendment pursuant to 2.116I5 did not arise.
So are you saying that there, even if there is a contractual claim available, that doesn't supplant the fact that there's still a common law tort claim?
Correct. Correct.
Counsel,
And-
you mentioned the size of the association, but the legal arguments you're making today would apply to an association if it had 10 members, would it
Well,
not?
I'm sorry, Your Honor. I think in that situation, you would have to look to the amount of control that the condo owner unit had. You know, if
Well,
it's
let's
a,
assume it's set up the exact same way with the same master deed, but there's only 10 units, right? One thing I've been having some difficulty with is the analogy to landlord and tenants with these homeowners associations or condo associations. A landlord has a pecuniary interest in the property and in attracting tenants and is paid every month, et cetera, rent. These associations, they don't make money, do they? Who has a pecuniary interest?
well, they
here?
don't make money, but there's certainly, this is a commercial transaction. You know, every month the homeowner, the condo owner has to pay a monthly fee. And not only that, when the condo owner sells, he doesn't get back his pro rata share of the reserves that he's paid or the money that he pays. It's kind of like if I go to a carnival, I'm just going in and I'm using the property. That's what's happening here. He's paying this fee to enter, to be able to enter and use the common areas. So I think, going back
There's
to
a
your...
payment of monthly dues that cover the basic maintenance expenses, whether it's grass or snow. That's what the association, basically why it exists, why it's required to exist, is it not?
It exists to maintain the premises, and for that, they are paid. They're paid for that service that they provide. Just like if you walk into a carnival, they're paid to provide the entertainment.
But what assets does the association have?
They have reserves.
Well, they're supposed to have reserves.
Well, it says in the
Sometimes-
master deed that they are, yes.
But sometimes they do and sometimes they don't. So I'm trying to understand what, if we're expanding liability here, you would think that we would be, maybe, and you would maybe be interested in suing somebody that had assets.
Well,
You know, for example, if you sue an individual and they, you get a judgment, you could attach their assets. But you can't attach the common areas, can you? I mean, can your client sort of take over the parking lot or the sidewalk, or how do
You know, I
how do
think-
you
Insurance
enforce the
coverage.
judgment?
I think what you could do is certainly get a judgment against them, and if by virtue of judgment that meant that the association had to raise the monthly dues, you could collect that way. Obviously, you could collect from their insurance company. Could you attach, could you garnish their reserve fund? Potentially you could, and then they would, again, in turn, have to increase their monthly dues. So yes, there are assets from which a plaintiff, if they got a judgment, could seek to collect.
Board members who serve in an uncompensated capacity, are they individually liable in some fashion?
I would imagine the master deed has an indemnification provision. I mean, if
This
you...
would be, the result of this, as my colleague has already mentioned, would be that homeowners associations and condo associations, large and small, would have to get insurance?
I think, as a practical matter, most of them do, and it's really no different than in the Jeffrey Moyes case, where the cooperative was sued, and they were responsible for maintaining the common areas, and the court held that because they had possession and control of the common areas, they had the duties of an invitee to the cooperative owners. It's the same situation. Those cooperatives are not in the business of making a profit.
My questions sort of go beyond just co-owners, extend to all lawsuits against these associations. I'm a member of one. I assume most of us are these days. Many housing developments are set up as site condominiums. For whatever reasons, the developers think that's a better way to set them up. So I'm just curious what it is we're after here. They're not landlords who own property and then have a pecuniary interest. And so why expand liability against associations?
Because, you know, it's not just the co-owners who can sue the association. Somebody else coming onto the land could potentially sue them as well for the dangerous conditions. So I don't think it makes a difference that it's the co-owner or the mailman. They have the responsibility. They have the possession and control. And under Michigan law, that's from the condition that from which the responsibility or the duty arises. So once they decided to assume that responsibility, that possession and control, they now have a duty. They have a duty to the people who are going to use that property. And if we're going to look and see what could possibly be the status of the condominium owner, the most apt analogy is to landlord-tenant, which is what the other courts around the country have concluded.
Justice Viviano raises an important point, and I'm just thinking that through, even for the small condo owner or homeowners association with maybe 10 units. Something's broken out in the common element area, is it the individual owner's job to go out and get their toolkit and fix it, or do they go to the homeowners association?
Well, I think by virtue of the language of the master deed as well as the condominium act, it has to be the homeowners association, because the condo owner is specifically precluded by the act from going out and in any way altering the common areas. So, you know, if there's a crack in the sidewalk, he can't go out and decide he's going to jackhammer it out. He's specifically precluded from that. And he also has given up the right to do that by ceding his possession and control rights to the association. And that's why I think there's a difference between maybe if you do have a very small association, you may be more of a joint enterprise because you're very small, you're all chipping in together, just you 5 or 10 people. But when you have hundreds of units, you don't have that right. You don't have that ability. You've given up all of that control, all of that ability to have a say in this to the association. And when they've taken that from you, they now have a responsibility and a duty to maintain it in a manner that's reasonably safe for your use.
So do we have to draw some line then? Say, this case, there's, homeowners association's responsible, they can be sued. A different case, so is it case by case? How would we draw that line?
Well, I think that when we're talking about this case in particular, the facts dictate that Mr. Janini did not have possession and control. It really comes down to that question, who has possession and control? Here, it's clearly the association. If there's no other questions right now, I'd like to reserve the rest of my time for rebuttal.
Good morning, Your Honors. May it please the Court, Nathan Sherbarth of Osmo PC on behalf of Defendant Appellee, London Townhouse Condominium Association. I'll waive the free fire period. I'm happy to take comments or questions. I think the key here, one of the key things that I wanted to focus on is this idea of possession and control as if that is dispositive of whether there is a duty owed in premises to Mr. Janini. And I submit that the possession and control inquiry is, of course, important. The premises possessor, controller, owner has to have those possession and control elements under FNAZO and all these other cases. But it still is, the existence of the duty is still dependent upon Mr. Janini's status on the premises. And Mr. Janini holds a fee interest, albeit it's a shared interest. He has a fee interest in the premises as a whole under his condominium ownership rights. He is a possessor of the premises. He's not an invitee. He's not been invited onto someone else's premises. It is his premises in essence. And so the idea that he has ceded possession and control, I think is also problematic. I think you could say that the association certainly controls the common areas in terms of maintenance and so forth. But Mr. Janini and his wife are members of that association. They all have a right to contribute to appear at board meetings, to make decisions collectively for the benefit of this condominium association. And I think the idea that he ceded possession is problematic because you have he still has a possessory interest. He has the right to use those common areas. They can't just kick him off of this premises based upon his fee ownership of his unit and a common interest in the premises.
Does he have a right to correct the defect?
Does he have a right to correct a defect?
He has a possessory right. Does he have a right to repair or maintain? That if the condo association is not fulfilling it, say it's a crack in the sidewalk, can he go and change the sidewalk to fix the defect?
I'm not sure if he could repair the crack. I think he could throw salt down. I don't know that he cannot
Based
alter
on
the
what?
character of it.
Why can he do the one and not the other? Is that controlled by the rights given and in the master deed?
Correct. They
So-
have maintenance responsibilities. But as you pointed out, Justice Kavanaugh, that is a breach of contract action. He has the right under the Condominium Act to bring a claim against his association if they're not doing something.
So could, you recognize he could bring a breach of contract action? Is that sort of inherently different than the tort action? Couldn't he, if he brought a breach of contract and says you have a contractual duty to maintain this common area, it's foreseeable that if you don't fulfill that duty and you breach it, then somebody's going to suffer injuries, and I could get every damage that I can get under a tort claim, I can get it through a contract claim.
Theoretically, he could. He didn't plead that here. But I think that that's a possibility. I think that there are other claims that he could bring, but he cannot bring a premises claim based upon his relation to the property. I think that is the fundamental distinction, is that he could maintain another type of claim if he can prove it, if he can show that they haven't maintained this properly. I don't know that he could show that here. I don't think he could, but he cannot maintain a claim based upon the premises. This corporeal element is really important here. He does not have the right to bring a premises claim because he does not fall within the trichotomy, invitee, licensee, or trespasser, the class of persons who can bring a premises claim.
What do you think about the third restatement that does away with those three categories?
I think that in this case, I don't think that it changes the result, because if we're going to extend a duty to someone who owns their own premises, it just doesn't apply in the condominium context. And I think that the nonprofit nature of this is really important. This condominium, Sister Council has made this point that we should look at other states that treat this like a landlord-tenant relationship. And I think that's a really inapt analogy, because there is this power dynamic that is just not present in the condominium or homeowners association context that you do have in a landlord-tenant situation. In the landlord-tenant context, you have a distinct imbalance of power. The landlord stands to, gain pecuniarily from the actions of renting out, letting someone use their premises. They own this premises, they let renters come on, they have pecuniary benefit. And an unscrupulous landlord may have a pecuniary benefit or an increased pecuniary benefit in failing to maintain the common areas if they do not have a duty to maintain those common areas. There is no similar incentive for a condominium association, which is made up of the owners, Mr. and Mrs. Janini, and the other owners, to somehow fail to maintain their premises. They're nonprofit. They take these fees in. They use those fees to hire a maintenance company to take care of the premises. They use it to take care of other issues that may arise in the premises, but they're not, the association doesn't stand to gain. So I think
But being a nonprofit isn't, there's lots of nonprofit entities that that lease space, so they still have a duty to their tenants.
Sure, but that's based upon their relationship between, their tenants I'm sorry, you're saying a nonprofit that leases space to someone else?
Yeah.
So they would owe a duty to their tenants, sure, because they're still profiting off of that rental.
Has to be a profit situation?
I don't think it has to be a profit situation, but I think Bailey v. Schaff is a good point to reference on that. And it talks about I think there's a quote I have. Special relationships giving rise to tort liability are predicated on an imbalance where one person entrusts himself to the control and protection of another, with the consequent loss of control to protect himself. But
So if you write a check every month to pay for the upkeep of the common elements, isn't that? doesn't
You're
that
required to be a
fit?
member in the association as well. You
Right.
have a say in how that association operates. The association does not have any incentive to fail to maintain because it is taking those funds in purely for the benefit of the collective
Okay, but let's assume they didn't
association.
maintain. They just didn't. There were some people who were in leadership who just weren't paying attention and didn't, do the normal contracts that they should have done to keep up the property. The homeowner in that situation has power to change that?
Yes, they have the power to sue their association under the Condominium Act.
Have the power to sue their association, but that doesn't alleviate the harm that would currently exist, right? I mean, under Justice Welch's question, the concern would be, okay, it's a dangerous situation. What happens until it gets cured? If no one cures it, what is the way to maintain a safe property?
I mean,
Doesn't it make it more, in a way, doesn't it just make it more dangerous or put you more at risk to be a member of the association than to not?
I'm not sure. But these are mandatory memberships. You have to be a member
Correct.
to live in this complex. It's part of the master deed. So there is a collective interest in maintaining safety. But I mean, I think the idea of not having recourse would be equally applicable in any circumstance. If you're using a premises, the only way that you're going to be able to get things changed is as the association. They have more control than anyone else would. Someone else might just have to sue, but if the association's not doing what they're supposed to do, they can go to meetings, they can make changes. But to your point, I guess, I don't think that this leaves them without recourse. Because again, if someone does get hurt, they could bring a claim based in contract. They could bring a claim against the maintenance company, which they did here, they dismissed it. There are other claims they can bring. It's just this unique nature of a premises claim that when you are talking about co-owners who have a fee interest in the premises, they don't fall under these categories, and they are not owed a duty by a nonprofit association of which they are a member.
What makes you so sure that land of another refers only to ownership of the land and not possession and control?
I'm sorry, say that again?
You're rather confident in the proposition that land of another refers only to ownership of the land and not possession and control of the land.
Oh, no, I don't think that that's necessary. I think in either circumstance, they certainly meet the definition of ownership, but they still have a possessory interest in the land. They may not have full control, but they have the right to possess the land. They cannot be excluded, and
But
that's
it's
what.
not possession or control, it's possession and control, isn't it?
They have to, well, they have, but as I've said, they still have this control interest in being a member of the association, and that's where we get to, say we have an association with 5 or 10 people. Okay, so are we going to make this a fact question every time as to how much control do they have
So the
because they have
control over
voting
the
rights?
common areas, you're saying, is their right to elect and fire and hold the board accountable? Is that the control that they have over the common areas?
Yes. Yeah, they do have that control. And they have more, and they have the right to sue if they're not doing what they're supposed to be doing. I mean, that's based upon their ownership
Doing
of this premises.
contract.
Correct.
Do you know, and this is way off, but are there insurance coverage difference for a condo association under a liability policy, whether it arises from premises liability as opposed to breach of the association's contractual duty?
I don't know. What I could say is that confidently, I think that expanding liability in this way would increase insurance premiums, and it would increase the exposure on these nonprofits. I mean,
Well, but aren't they, the association is still going to be liable. Here it happened to be a co-owner, but they're still liable for failing to maintain their premises if it's a guest.
correct.
Right? They can still
Yeah.
be sued. They still have insurance They take out an insurance policy to protect against that.
Correct. But
So-
these premises owners are on the premises every day, all day.
But, and haven't other states somehow figured this out? I mean, are we an outlier on this?
No, I don't think we are an outlier. I think there's a few states, and plaintiffs have cited some cases that treat this as a landlord-tenant situation. And I've addressed why I don't think it is a good analogy. But there are other states such as Indiana, Colorado, and Mississippi that see that this ownership interest means something, and that you cannot be you do not fall under these categories of invitee licensing and so forth when you are an owner of the premises, when you have that possession and control that comes with being a condo association owner. I don't think we're an outlier. I think we have a very well developed premises liability jurisprudence. So I think the last point that I would make is that, again, this would expand liability on these condo associations. And the reality is these are nonprofits that are collecting everything that they have to maintain these condo units and developments based upon the payments, the fees that are collected from people like Mr. Janini. As Sister Counsel brought up, sure, if you expand the liability, you might be able to collect more fees. But the reality is condos are a great alternative to single-family homeownership, partially because there is a collective benefit. The collective maintenance, the collective nature of it means that individuals who may not be able to afford single-family homeownership, which is getting absurdly expensive, may be able to afford condo ownership. And any expansion of liability is necessarily going to have some effect on their ability to take part in that. I'm happy to answer any other questions, otherwise I'll rest of my briefs. Thank you.
Thank you. Just a few points I'd like to raise. With respect to the last point that Brother Counsel raised, you pay more for a condo or for a condominium because you are getting that association. There's a financial penalty to you by buying into associations such as this, but I don't think that that's the real issue. The real issue is that you don't have real possession or control once you've given those rights to the association. Both the Merritt case and the Finazzo case clearly said that ownership is one thing the court can look to see if you have possession and control, but it's certainly not dispositive. Those rights can be transferred, and in this case, and in virtually all condominium owner association cases, those rights have in fact been transferred. And the point was raised that, well, Mr. Janini still had the right to use these common areas because he had some possession interest. He had the right to use them only because after he transferred his possession interests, he paid his monthly fees. In fact, the Court of Appeals in this case specifically indicated that his right to use the common areas was conditioned upon him paying the fees and otherwise complying with the bylaws. So that when you're talking about where does the pecuniary interest of the association come in, it is in relation to his right to use this area after he's transferred his rights to it by paying his monthly fees. It's dependent on that. With respect to the other states that have dealt with this, I would just point out, counsel indicated that the holding in the Indiana case has been overruled, that Indiana now agrees with most of the other states around the country that the condo owner should be treated like an invitee and the association should be treated like an invitor because their responsibilities are so analogous. So for those reasons, Your Honor, we would ask that the decision of the Court of Appeals be reversed and that of the Franchiuti case also be reversed. Thank you.
Thank you. Thank you both. The case will be submitted, and the court will stand in recess until 12:45.